wish to close our case. Not be calling any further witnesses. Second one, but considering how the last time when court and this time when court would like to move the matter forward, and I believe the plaintiff's testimony is enough. So I'd like to seek an adjournment for.
Yes, I had written to my colleagues. I was served with a hearing notice from the Court of Appeal to appear before the Court of Appeal tomorrow. This is in civil application E406 of 2025. Garden Estate Limited versus Gulbano, daughter of January. Two others.
You are supposed to appear before the Court of Appeal tomorrow?
Yes. The hearing notice was served upon us on 9th of October. I wrote to my colleagues last week and I attached the hearing notice. The date has been imposed on us. Unfortunately, when we don't really have a choice. So tomorrow I'll be engaged in the Court of Appeal at 9 a.m. I don't know what time I may conclude. That's Garden Estate Limited versus Gulbano, daughter of Jan Mohammed and two others.
No, the civil application number?
E406
of
2025.
2025?
Yes, the stay application number 5 to
A stay application doesn't take long. From what I understand, the Court of Appeal gives you 10 minutes max to submit. And they do these applications for stays almost every other day.
Then,
Yes?
maybe my lady, can we maybe mention after your call over? If I'll be done, then I'm ready to proceed. Only that I thought it would be prudent to inform my colleagues because I didn't want to keep them waiting.
It's important to inform them. So if we are proceeding tomorrow, it will be the first to fifth defendant's case.
That's right, my lady. One counsel address. Sorry.
Yeah, still on another housekeeping issue. For the sixth defendant, initially we had intended to call two witnesses. Hearing is no longer available. We have filed a replacement witness statement by Sarah, also dated to have my colleagues. Content is almost similar, but I just thought to mention it at this stage. I request that leave that it be properly deemed to be on record. You know that Martin's inability to testify came up a bit later and we had to replace him. The 30th of September, and I served my colleagues. I served them on just slight differences in position and just who is signing the statement.
To object to it being admitted to the record, first of all, it's out of time, well out of time. This is a year after we were last in court. And secondly, what that so-called supplementary witness statement is, it is basically Martin Kiari's witness statement, copy-pasted and with Sarah Oso's name on it. It's exactly the same. It's not similar, it is exactly a carbon copy. And so it doesn't really make sense that someone else is not going to testify someone else's witness statement when originally they were not testifying.
Also filed a witness statement before.
She had filed a witness statement, and the contents of it are completely different from this supplementary witness statement. But more to the point, this supplementary witness statement now being filed in Sarah Oso's name was initially filed under Martin Kiari's name, word for word. So they've just changed the name on the witness statement. And we feel it will be a waste of the court's time to go through cross-examining Sarah Oso on issues she had never even raised initially, just because they've lost a witness. Or issues she might not even have knowledge of. That is.
Well, she'll be tested in cross-examination. You'll test her knowledge or lack of it in cross-examination. Isn't it?
Yes, your leadership, we are ready to take direction, but I felt I had to put this on the record. My objection has to be on the record, on the timing and also on the nature of the supplementary witness statement. We will take the court's direction either way. Tomorrow, we were served with a notice that counsel might not be able to attend because of this Court of Appeal, and hearing that he has been summoned to, and I come from Mombasa and I made arrangements accordingly, knowing that the matter will probably not continue. And so if if
I think you should not have made arrangements to travel back until the court, you are sure the matter will not proceed. Dates are very hard to come by.
Yes,
Mr.
I agree.
Asige.
I agree. I agree. My only concern is if he's there for longer than we anticipate. That is my only concern. And then the matter has to
Because
be
the dates available now are for next year. I
Oh.
think in March and others for fresh matters, we are giving them dates in June.
In that case, we take the court's direction.
So you had made a
Very well, my lady.
Much obliged, Your Honor.
yes. He'll give you accommodation allowance.
Lady, I'll be ready to proceed with one witness for the first to fifth defendants.
Substitution of the witness.
No objection to the substitution of the witness.
I think I saw it in the court file.
29 September 2025.
This case will be mentioned tomorrow at 10:30 a.m. to confirm. We'll be through with the Court of Appeal matter by then. If he will, then we'll proceed to hearing. If he will, we'll proceed for hearing at 11:30 a.m. in this same place. The first to fifth defendant's case. I don't think we'll manage to reach your witness, but she should come just in case. I allow the substitution of the sixth defendant's witness with Ms. Sarah Ouso. Is she Ouso? Sarah Ouso. I do not see any prejudice that will be occasioned to the plaintiff, as her advocate will cross-examine the said witness to test the veracity of the contents of her witness statement dated 29th of September 2025, which I deem to be properly on record. Okay. Thank you and have a good afternoon.
Thank you.